the property management industry, fair housing offenses are considered especially troubling. In the United States, a dedicated fair housing attorney, Leslie Tucker, provides case explanations and best practices. These are some cases.
Hello, everyone. Welcome to the Fair Housing Insiders Case Files, Episode 19 with Leslie Tucker, the principal of Williams, Edelstein, and Tucker. I'm your host, Jonathan Sarr. This case that Leslie is going to help us with today brings forward allegations of racial discrimination involving the refusal to provide an accessible parking space to a Black buyer, a stark contrast to an earlier agreement made with a white resident. Leslie, with this case touching on critical aspects of discrimination and accessibility rights, what are your insights on these developments?
Yeah, so let's get into more of the facts of this case. The defendants in this case are a condominium community and the condo's management company. The plaintiff is a Black condo owner who has a mental disability. This condo owner has a state-issued parking placard due to her mental disability so that she can park close to building entrances and avoid crowds. The condominium here at issue has 64 parking spaces, 3 of which are designated as accessible. And these accessible parking spaces are identified as accessible in the condo's bylaws. Really, if they're available, anyone can purchase any space. There's really no restriction on that. But the bylaws do say that if someone who's not disabled purchases one of the accessible spaces, they must either lease or swap the space if a disabled individual requests the space. So in mid-2021, a white condo owner asked the management company about obtaining one of the accessible parking spaces. She was allegedly told that yes, she could purchase one of the spaces for $50,000. She ultimately decided against it. Okay, fast forward maybe 6 months. In early 2022, the plaintiff asked the manager about obtaining an accessible parking space. The alleged response was that neither the HOA nor the management company owns the parking spaces or handles the sale of any of them. The plaintiff was also allegedly told that there were no parking spaces designated as handicap, which is the term they use, not me. When she asked about a month later, she was allegedly told that one of the spaces had been purchased by the other unit owners. Actually, all of them had been purchased by the other unit owners. She came back a third time a few months later and was told that all the spaces had been deeded to the other unit owners and that all the accessible spaces had been converted to regular spaces. Therefore, there were none. The plaintiff happened to have spoken to the white condo owner who had previously been offered the opportunity to purchase an accessible space. She believed that the only difference between their two requests was their race. So she filed a complaint with HUD, and HUD found cause to believe that a violation had occurred. This case was subsequently filed in federal court, which is where it stands now.
Okay. Lots of detail and time involved with this. So very good. Thank you, Leslie. So my first question, is a management company required to approve a request for an accessible space for someone with a mental disability?
Well, the request for a reserved accessible space is a reasonable accommodation. So I don't want to make a generalized statement because you need to process every request separately on a case-by-case basis. Every request is different and unique, but I will say that I generally tend to think that for an accessible space, someone with a purely psychological or mental disability probably would not need the features of that accessible space. Accessible parking is intended to accommodate individuals with mobility impairments, which is the purpose of having that access aisle immediately adjacent, which helps with accommodating wheelchairs and walkers and scooters and things like that. Although some people may have obtained a parking placard, like the plaintiff in this case, in a rental community, that wouldn't necessarily entitle the resident to have their own reserved accessible space. For someone like the plaintiff who has no mobility impairment, management probably would have been justified in offering a standard regular space, but close to the entrance, which I think is, what her needs were. She needed to be closer to the entrance. So accommodating her in that way, in the location of the space, I think probably would have been appropriate rather than giving her own accessible space.
Okay, understood. So then what was wrong with what the defendants allegedly did? What was wrong with what the defendants allegedly did in this particular situation?
Well, a condominium is different from a rental community in that the residents purchase their parking spaces. It's not simply just kind of casually assigned by management. And the bylaws for this condo community didn't restrict who could purchase which space. If there were legitimately no parking spaces available for purchase, there probably would have been no issue. But if the facts as alleged are true, I see two main issues, which is what led to this complaint being filed ultimately. And that is that the information that management gave to the plaintiff conflicted with the information in the bylaws. I mean, I think this put up a red flag for the plaintiff. The bylaws specifically reference 3 accessible parking spaces and how that must be handled if someone with a disability needs one of those spaces. However, the complaint alleges that management told the plaintiff something different, that there were no accessible spaces at the community. So that's the first problem that I saw, again, if the facts as alleged are true. And the second was obviously the difference between the responses given to the white resident versus the response given to the plaintiff who is Black. So, kind of aside from whether the plaintiff truly needed the space or not, wasn't really the issue. The issue was that, she believed that she was being treated differently based on her race for the 2 reasons that I just mentioned.
Got it. Thanks for it's a complicated case, but
it is.
It highlights a lot of different things for our community to give some thought on for sure. So thank you for your explanation and your legal perspective on this particular case today. So thank you to our community. This has been episode 19 of the Fair Housing Insiders Case Files. Thank you again, Leslie. Until next time, take care, everyone.